All right, good afternoon, everyone. I'm Sean O'Neill. I am the Compliance and Privacy Officer for Vault Workforce Screening. Vault is a trusted workforce screening and recovery management partner, supporting clients ranging from government agencies to Fortune 500 companies in the design and management of their programs for the last 34 years. We want to welcome you today to our final webinar of the year, 2023 Screening Reflections. Experts take on our most asked questions. We have a large group of experts with us today across the entire company. On the panel is Dr. Suzanne Steele, our Chief MRO for Workplace Testing, Dr. Jim Ferguson, our Medical Director for Recovery Management, Tyra Lawson, our Director of Background Screening, Regina Doral, our General Manager of Compliance Services, and Melanie Santiago, our Senior Director of Operations. Our webinar today will include a 10 to 15 minute Q&A session at the end. Today's presentation will also be recorded, and it will be circulated to everyone for your reference after our time together comes to a close. Before we begin, we want to make sure that you are aware the information and opinions expressed are for educational purposes only, and they're based on current practice, industry knowledge, and business expertise. This information we're going to share with you today should not be construed as legal advice, express or implied. We recommend you always consult with your legal counsel before you take any action in relation to information disseminated during today's webinar. For today's webinar, we're going to cover three areas. We're going to cover drug testing, which will include both workplace drug testing and recovery management drug testing. We're going to cover occupational health, and we're going to cover background screening. We're going to start by going through some of the questions that were submitted upon registration, as well as some of the common questions our experts have received throughout the year. But again, please use that Q&A feature, and we'll get to those questions at the end. Today, we hope you walk away with three things. One, insights on workplace drug testing, recovery management drug testing, occupational health, and background screening. We hope this helps you navigate regulatory compliance, and we hope that we allow you time to ask questions and get the answers from our experts who are assembled here today. All right, with that, experts, are you ready to start the questions? All right, nodding heads, excellent. We're going to start with the most common question that we have received in 2023, and it actually applies to all areas of the business. And that is, why is my result delayed? Or why is my report delayed? Or why is my document delayed? Let's turn this over to our experts. Tyra, let's start with you. What happens that causes delays in background screening?
Delays in background screenings are caused by a variety of things. They include not having necessary forms or needing to collect forms, some for specific jurisdictions. On the public record standpoint, they're caused by just long turnaround times in general and staffing at courts. There are some areas that are just known to be trouble areas in regards to that turnaround time. From an employment and education, usually it has to do with holiday closures.
Okay. Let's jump over to Occ Health. Melanie, what causes delays in your area?
In my area, when we talk about Occ Health, we're talking about anything from a DOT commercial driver medical exam to a basic physical. And these results are primarily delayed when you use the non-electronic version of these services because they don't automatically get sent across, or the results don't automatically feed back to us. So using an electronic platform as much as possible, and when using an electronic form, making sure the sites know where to send it is the best way to avoid delays.
Okay. Dr. Ferguson, what about in your space in recovery management? What causes delays on results being able to report out?
Whole bunch of things. You have to break it up into everything that goes into getting a result, from collection to transport to the lab, to testing at the lab, to upload from the lab. Some collection sites are out in the middle of nowhere. Collection pickups doesn't happen as rapidly as we'd like it to. Sometimes transport from the site to the lab is delayed. You have to look at all of those things, weather delays, different types of cancellations. Recovery management panels, unlike a lot of workplace panels, are really big sometimes. And the more analytes you have to test, the more presumptive positives that might wind up going to confirmation. Lab turnaround time is longer for the non-negatives, shouldn't be any longer for the negatives. But before we can give you an across-the-board answer, you've got to look at all the pieces of the drug testing process.
Regina, Dr. Steele, what about on the workplace side of drug testing? Dr. Ferguson covered a lot of the delays. Anything else on the workplace side?
I would think on the I know on the workplace side, some of the other delays are caused by collector errors, and it might be an error that they didn't sign something on the paperwork, or they forget to fill out a block, they forgot to check the temperature, they forgot to check the observe box, or any of those things. All those things have to be finalized before the lab would report it to the MRO, or the MRO reports it out to the employer. That's a big cause of the delays there.
And for us, we have to reach the donors. We're trying at least 3 times to call them over a span of 24 hours. And then we're hoping that they call us back. We're reaching out to the DER, designated employee representative, if we can't reach them, and seeing if we can still get them. And depending on the regulation, we either have to hold the test for up to a 10-day hold from the import date, or we can hold it for a shorter amount of time if it's not a DOT case. If you know that you reached out to a donor and made contact with them and you let us know, we can release it sooner sometimes, because then they have less time to call us back if it's a DOT case, Department of Transportation, that federally regulated case.
And a follow-up question from each of your prospective areas, what can you tell the employer or the program what is causing the delay? What can you share about why a result is delayed before it reports out? What can't we share? Regina, Dr. Steele, let's start with you in workplace drug testing. How much information can you share about a pending result?
For workplace, I'd say very little, because the DOT regulations limit what we can tell the employer, even after the MRO has the result. We can tell them if we're missing a form, we're missing a chain of custody. If we know that there's some correction needed, we can tell them what we're working with the collection site to get an affidavit. But there's not a lot else that we can give them for that, unless it gets to the point where there's certain things in the regulation where the MRO is supposed to reach out to the employer.
Dr. Ferguson, what about in RMS? What are you able to share with the programs while a result is pending?
This is one of the areas we're different than workplace, because we do things that you can't do in workplace, and I can share pretty much anything. And sometimes I have to, because some of our panels and some of our results are complicated enough, just like one we did today about was initially reported as a refusal to test. We had to do a whole lot of background work on that, and I had to do every step in conjunction with the client. We follow the forensic model HHS and DOT put out everywhere we can, but sometimes we just can't.
Tyra, background screening?
On background screening, it's going to depend on the product. With educations and employments, we can share the information that we have. With public records, we can share very little. A lot of that has to do with the Fair Credit Reporting Act. If we share something and you take action on that and a different result returns, we have potential for legal issues. We don't share because we don't want negative actions to happen.
Mel, I haven't forgot about you. What about OCHealth? What are you able to share on pending documents or reports?
Yeah, the primary limitation in the OCHealth space is on the commercial driver medical exam or the DOT physical. We can't tell employers generally what the medical condition is that's holding it up, just for privacy reasons. But outside of that, if the basic physical is on hold for a signature or something like that, we can certainly be pretty transparent about what's going on with those documents.
Great. All right, let's move into our first area following that, and we're going to start with drug testing. We're going to talk about workplace and recovery management. Our first question, I'm going to throw this out to Dr. Steele and Dr. Ferguson. Does a drug test determine if the individual who was tested is impaired? Dr. Steele, let's start with you. Does drug testing detect impairment?
In most cases, it does not. unless you're doing a breath alcohol test and you have something over the legal limit, then you're going to suspect impairment. But in other cases, we can't necessarily detect if somebody's impaired. The only thing we're tasked and asking when we do the test is, has the person consumed this particular product? That's what we're asking, and that's the answer that we get.
Dr. Ferguson, anything to add?
Drug tests are historical records. Dr. Seal hit the only one that you can tell, which is, either blood or breath alcohol. But they're historical records, and the detection period can go anywhere from 3 to 5 days back to 90 days if it's scalp hair, and way longer if it's body hair. So, nope. Only thing we can tell is ingestion versus contamination sometimes.
Okay. Our next question, why do MROs sometimes send a letter of safety concern? Dr. Seal.
There's 3 main categories. And the first one is if the person is determined to be consuming a medication that might impair them while they're working, or if that medication's at a dose that is concerning, or if it's being combined with other medications that would make them concerning. If somebody's taking something that might make them sedated while they're working, for instance, then we're going to send a safety concern notification. It's a form letter, and it doesn't say typically what medication they're taking, but it does indicate that we're concerned about a medication. The second category is a medical condition. If somebody says they just had a heart attack, they just developed seizures, there's lots of medical conditions where we might say, hey, that's a safety concern. That person shouldn't be driving a tractor trailer truck, or that person might not be capable to perform their safety sensitive duties. Then again, it's a form letter, and we're letting you know that we have a concern about a medical condition. And the last category is if somebody is found to be positive for opiates, morphine or codeine, lower than the detection limit of 15,000, and they have not provided a legitimate medical source, and they're negative for something that we test for that indicates they're not necessarily using heroin. Since we don't have a source, and the source might be illicit substance use or something that they've taken, for instance, off a patient at work, they're somebody who has access to the medications, then we're going to indicate that they could be sent for a physical to determine if there's illicit substance use. That's the third category down.
Great. Dr. Ferguson, I know you're not really sending letters of safety concern in your space, but anything you would want to add from an MRO space in general?
Oh, just very quickly, because you can spend an hour talking about this, but everybody's hated 40.327 ever since DOT put it out there. You have to be so nebulous, you have to be so careful about it, and there's issues of liability involved here too. So it's a good space for collaboration. I will say that as real quickly, Sean, as DTAB and HHS-DWP has been going on with the future of drug testing, that requirement, by the way, for safety letters is not mirrored in the HHS guidelines for federal workplace testing. They don't do that. The question is, how are we going to make that better as time goes on, especially with the descheduling of marijuana, this potential on the horizon? And the future of MRO is going to become much more of a fit for duty type of job than it is right now. That's just a hint of things to come. And I'll stop now.
And Dr. Ferguson, great pitch out there for, we could talk about an hour on safety letters.
I did that on purpose because she's going to be great. I know what she's going to be great.
All right, let's go to the next one. Dr. Ferguson, I'm going to throw this one out to you. Could the explanation provided by the donor, and fill in the blank here, whether it's something they've read on the internet, CBD, some other product, could that provided have caused the result or a false positive?
Maybe.
Okay.
Now listen, there's 3 questions here. They're sequential, and I'm probably going to hit them all here, Sean, because they do follow. The first thing about this that I want everybody to know, whether it's monitoring or workplace, is you can hit the internet and get a whole lot of information. But if you read real closely on what you're reading on the internet, all of those interferences and false positives and things that people are screaming about are at one stage of the testing process, and that's called screening. And usually, specifically, immunoassay screening. Okay, everybody on this call ought to know that you're never going to get a result from Vault that has only been screened by immunoassays. As a matter of fact, in the biz, we don't even call them positives. We call them presumptive results. And every time there's a presumptive screening result, and remember, screening is more sensitive, but it's not very specific. Every time there's a presumptive result, it goes to confirmation. Now, confirmation is as sensitive, sometimes more sensitive, and it's also very specific. When you get a confirmation answer, it's at the molecular level. The false positives and the mess ups you read about on the internet don't happen at confirmation. Sadly, what might happen at confirmation is the human beings mess up, because you can spend millions of dollars on laboratory equipment. It's still run by humans. And it's not easy to run that lab equipment. It takes a lot of skill, a lot of patience. That's why we have something called a split specimen process. And yep, in monitoring, just like in workplace, we do split specimens all the time. Okay, that means bottle B, the second part of a specimen that has been split, a collection, goes over to another lab, same certifications, same machines, same people, with same training, same process for reconfirmation. And that's the only thing, this is the answer to the third one of these questions in a row, that's the only thing that invalidates a drug test result. If the split specimen doesn't reconfirm the initial result, results are canceled. That's the safety factor we have in case there's a mess up at the laboratory. Very rarely, can't say never, but very rarely does that happen. Okay, that's the lab piece. Poppy seeds, CBD, those kind of excuses, not such a big deal in workplace, especially once SAMHSA gets the morphine cutoff up higher, like they are going to do next year. But remember, we're monitoring is much more of a detection program, workplace deterrent program. We're looking much more toward detection. All those very protective high cutoffs that workplace uses, we don't use them so much. Our cutoffs could go way, way down. Plus, we also pay a lot more attention to specimen concentration, creatinine levels. We can see things like poppy seed positives, and we see them a lot. We have to deal with dilute specimens in ways that are very different because the testing is inaccurate when you have a dilute specimen. Explanations that might not fly in workplace can potentially fly here. The main one, of course, being poppy seeds. In both sides of our business, CBD can, this is an answer to a question on farther on down, CBD can certainly cause THCA, marijuana metabolite positives. It can. And in my side of the business, particularly, I can put a lot more comments on my reviews than the workplace can. And I have an expression that I think probably a lot of people listening may be really tired of hearing me say. This donor's explanation is feasible, but not verifiable. Feasible, but not verifiable. Sometimes, of course, they are not feasible. You get a couple 100,000 nanograms per milliliter of ETG, then, no, that did not cause from hand sanitizer. That didn't come from that. But in some cases, what we hear is feasible and not verifiable. And then we go in monitoring, which you can't do too much in workplace. We get the benefit of doing follow-up testing. A follow-up testing, just like I said before, does not invalidate the initial result, but it puts it in perspective. It puts it in perspective. A hair test after a poppy seed, a potential poppy seed positive in urine should be negative, because poppy seeds don't cause positive morphine or codeine in hair. They just don't. And sometimes we recommend that, not to invalidate the urine, but to put it in perspective. We choose follow-up matrices specifically because they need to have a detection window that covers the period of time we're concerned about. They also need to be able to test for the same analyte. And the thing about hair panels and nail panels is they're getting better, but they're not as big as urine panels. And there are going to be some analytes that you just can't do that with. Phosphatidylethanol is only a test for an alcohol metabolite. All of those detection windows are approximate. They're not cut in stone. And none of those other matrices are as sensitive as the urine, which is why they don't invalidate the urine, which is why they put them in perspective.
Dr. Ferguson, you mentioned follow-up testing, and I know in the RMS side, one of the questions you commonly get asked is, what is the best follow-up testing option? How do you answer that?
Anything that covers the amount, the period of time you're concerned about covering, and anything that best looks for the specific analyte that we're concerned about verifying. I just used the example of poppy seeds testing positive for codeine or morphine. The good news is that most hair panels have those old-fashioned opiates in them. You can do a fairly limited hair panel and cover that. If, on the other hand, you got a very low fentanyl cutoff, that's not so easy because of the nature of fentanyl and the nature of the fentanyl metabolite. But we want to cover something, we want to choose a specimen that will test for the analyte and look for it in the period of time that we are looking for. The good news about monitoring, it doesn't happen in workplaces. There's so much testing going on. A whole lot of times when we finish the non-negative review, there's already a follow-up negative that's been posted because that's how frequently people get tested. That doesn't mean we still don't recommend a specific alternative specimen to follow up on for the perspective.
Great. All right, Dr. Steele, I want to go back to you on this one. Anything you would add from a workplace side? I know Dr. Ferguson covered both RMS and workplace, but anything you would add from what in the workplace testing?
Dr. Ferguson already said it, but I have a way of remembering it. I always think of the confirmation test being the fingerprint for that particular chemical. So if you remember that the screen is where we can have the false positives, the confirmation, which is usually gas or liquid chromatography mass spectrometry, it's a peak that only matches that particular analyte. I like to think of it as the fingerprint for that chemical.
Right. Does a follow-up alternative specimen invalidate that urine positive, Dr. Ferguson, on your side of the house?
No, I've said that, and the answer is absolutely not. The only thing that does is a split specimen that doesn't reconfirm. Like I say, in my side, probably more than workplace side, although you could argue whether that's a good thing or a bad thing, we need perspective. We need perspective because sometimes people's status in a monitoring program depends on one drug test result. And when the status in a monitoring program depends on it, the medical license or a nursing license may also depend on that. We're talking careers here. We need perspective, and we do everything we can to get as much perspective to make the governing body, be it a medical board, a PHP, physician's health program, or whoever the governing body is, can make an intelligent decision about moving forward.
Next question we get, and this one we've gotten a lot this year, is what changes are coming to drug testing in California and Washington? I'm going to take this one. There are some changes coming. January of 2024, right around the corner. California passed a law this year that basically is going to make it challenging to test for THC on a drug test for employment purposes. The way it's written, employers are not able to take action on a drug test that tests for non-psychoactive metabolites of THC. As Dr. Ferguson and Dr. Steele covered earlier, drug testing doesn't detect impairment, it detects history. This makes urine drug testing very challenging for employers. California has an exception for the construction industry. That's about it, or anything federal related. If you are testing in California on your non-DOT panel and you're testing for THC, get with your legal counsel, take a hard look at that, because come January, you might be in a sticky situation. Washington, very similar, actually very similar language to how California wrote their law, but Washington made it a little bit more broad. Washington's law addresses pre-employment testing only. California addresses all testing. Washington also has a number of exclusions in the law, including safety-sensitive functions and a number of industries where, again, California only excluded the construction industry. If you do have employees, applicants who you are testing outside of any federal regulated testing, you need to get with your legal counsel and take a hard look at what your testing is in California and Washington, because you may have to change that. And if you need assistance on that, this team of experts is here to help you with it. All right, Regina, we're going to throw this one over to you now. It's been around for 3 years, but we still get questions. Can you do a brief explanation as to the clearinghouse process?
Yes, the clearinghouse pertains only to FMCSA covered results. If the test was taken by any other agency or non-DOT, it doesn't apply to the clearinghouse. That's the biggest thing we get. Can I enter this result? It's a non-DOT. No, it's only FMCSA covered results. And then for that, the MRO enters all positive results. If the MRO reported out a positive result to you, the MRO is going to enter that. And unfortunately, the employer is not going to be able to see it. They have no viewing of anything that the MRO enters, only things they enter themselves. The employer, though, is responsible for a few results. They have to enter refusal to test, they have to enter actual knowledge results, and alcohol results they have to enter. The employer also has to enter any return to duty and follow-up program results that are taking place from there. The other responsibilities in the clearinghouse come under the background check side, and they're the queries. Tyra, are you on? Do you want to talk a little bit about that?
I can absolutely talk about queries. And queries are the pre-employment queries that are done on that FMCSA clearinghouse. It's basically what the employer can see of what's been put into it, what's been put into the clearinghouse. It's something that has to be done on a pre-employment basis, and then it has to be done at least once a year. That individual who is regulated by FMCSA is employed by you. Anytime they're put into a new placement under a new DOT number, you need to have that pre-employment check, and then annually to see if they have any results from a drug and alcohol test of any sort, and then whether or not they're in a type of return to work program.
Great. All right. I think one of the other common questions we've gotten this year, especially the second half of the year, is what's the latest information on DOT oral fluid drug testing? Regina, I'll start with you, and then we'll circle around to Dr. Ferguson and Dr. Steele. What are we hearing on DOT oral fluid? When can we start testing for oral fluids under Department of Transportation?
That is the question. When can we do it? As most people know, DOT did approve it in June. It went into place in June. However, because there's not a device, nor is there any labs that are currently certified, you can't do it yet. Yes, it's been approved, and yes, everybody's working towards that goal. Do we have a date yet? No. I was just on that, Dr. Ferguson mentioned the DTAP meeting, and I listened in on it last week, and one of the things that they mentioned was there's no labs that have applied yet for certification. But the reason they didn't apply is because the device hasn't been approved yet, because they have to have the device being approved for the lab to apply. Hopefully, yes, in the near future, it would be great, but at the moment, we can't start it.
All right. Dr. Ferguson, Dr. Steele, anything else you would add? Anything in the crystal ball that you can see when oral fluid will be here?
The thing to remember, in addition to what Regina said, is that unlike hair, unlike urine, or the lab ability to become certified is dependent on the device. In other words, labs are certified by the device. FDA in the last DTAB meeting did put out a expedited clearance process, but remember, those devices for federal testing have to be FDA cleared. You got so many multiple things falling in line that have to happen first. The labs can't even begin to think about it until the device is approved. And you have to know that the lab B that you're going to use for those specimens that we talked about is approved for the same device that lab A tested. End of 2024, maybe?
Okay.
I could just add that we're looking forward to it because oral fluid collection is already observed And eventually we'll be able to switch back and forth. Maybe we'll have some relief from the shy bladder evaluations if someone's not able to urinate and then they get permission to switch the oral fluid, then we might be able to get the test completed that day instead of at a delayed time.
Great. All right, drug testing experts, thank you. We're going to give you a break and we'll bring you back at the end for question and answer, but we're going to move over to our occupational health section now. Melanie, bringing you back. Let's start with commercial driver exams. You mentioned them at the top when you talked about delays. How can an employer prepare their drivers for their DOT physical to avoid delays?
Yeah, I think the biggest preventative would be making sure the driver is aware of what's going to be asked of them on the form. If they have any major medical conditions, what type of documentation is recommended that they bring. Vault does offer clients a document that we can customize called the Prepare for Your Physical document, where it touches on all the key common issues, diabetes, sleep apnea, and so on, that the employers can share with their drivers as part of either the pre-employment process or the recertification process or both. If anyone on the call is interested, you can reach out to me directly.
Great. You mentioned having forms, bringing forms with sleep apnea. That's one of the most common ones I think we see, bringing a sleep study or bringing compliance data. Why is sleep apnea? How does sleep apnea impact the safety and performance of truck drivers? Why is this such a hot topic with driver physicals?
Yeah, it's a loaded question, and I'm not a medical professional, but at the high level, sleep apnea makes you tired if it's not treated. And we all know how fatigue affects the fleet. We want to avoid fatigue. We want them to be treating the sleep apnea. And also untreated sleep apnea is known to cause other comorbidities like diabetes, high blood pressure. It can really compound on a driver who's not taking care of themselves and significantly impact safety.
If a driver has been diagnosed with sleep apnea or has taken a sleep study in the past, should they bring that information with them to their physical?
Always, yeah. The physical doesn't limit them to any certain time frame that they should be disclosing things in their lifetime. If they can bring that, I would always recommend it. Each examiner is a little different on what they require or how far back they want to go. That part's kind of examiner discretion. It's better safe than sorry.
Great. Broadly, moving away from just driver physicals, but let's talk OC health in general, or actually scheduling anything in general with the clinic. What should an employer confirm with the clinic before they send their employee or their applicant in for services?
Yeah, for anyone on the call that uses our first request ordering tool, you'll know that there's a way to select your site for the services that you want done, and it's pretty user-friendly, but there's always a chance that we have not been notified that a site's hours have changed or their services have changed, or today they don't have an examiner to do X service. We always recommend that you call ahead, verify the hours of operation, verify that the service that you're ordering is in stock. If it's a flu vaccine, it's a day-by-day race to try to get those in stock, and they move quickly in the sites. If you require special forms to be completed, you're not willing to accept the client's version of a physical, for example, it's always important to call ahead and verify that that site supports that. Sometimes they refuse. Sometimes they only use their forms, or in a lot of cases, they'll use the vault forms, but not a special form. Checking all of that would be important.
Great. You mentioned special forms, leads into our last question in the OC health space. What is a special form, and why do special forms cause delay at the clinics? Can you talk more about that?
Yeah, a lot of staffing companies specifically have clients that require a special physical form on a specific letterhead with specific questions, and it can apply to any other services as well, but I see it most commonly on the physical. And some clinics won't fill that form out. They want to use their own. A lot of them have agreed to start using the vault version of the forms. We try to work with clients to make sure we're putting in the request in a way that you get your result back as quickly as possible without delays. I did want to note that on the last question when we talk about confirming things with the clinic and also special forms. These things can, if you work with your account representative, be pre-programmed in our system. You can take advantage of the confirming services feature that we have, and you can also kind of preload forms once we get sites on board in our system for ease of use.
Do you want to talk a little bit more about that? What does it mean to preload forms? What is the benefit of that?
Yeah, it actually goes out with the authorization to the site. They have a clean, empty version of the form on hand every time the donor goes in. If it's always you want to use X form for X service all the time, we can preload that. We can also set it up by divisions. It gets pretty fancy, but I would work with your account rep if you're interested in looking into that.
Great. Thanks, Mel. We're going to give you a break now, and we're going to move over to background screening. We'll bring you back at the end for questions. Tyra, welcome back. I think the phrase I heard the most in background screening this year is clean slate state, which is a mouthful to say. What does it mean to be a clean slate state?
Clean slate state is a mouthful. To be a clean slate state is a state that is basically purging criminal convictions. They do it within a set guideline of what that state has determined, and then in a set time frame, and they go through and they remove those convictions from their system. It's an opportunity to give those who have been convicted of things such as petty theft, small drug charges, small fighting charges, a second chance. We have such a large population that has a lot of these small type charges that really prevent them from getting jobs. And they do it in an effort to give that individual a second chance, get them into the workforce, and get them to being in the economy. This is something that's going to continue to happen more and more. Right now, we have about 20 states that have passed some sort of clean slate legislation, but not all of them have been able to go through and begin to do that record purging. This year, we really heard it thanks to Michigan. Michigan took quite a few months to go through and purge, and one county is still in the process of purging. But this is something we're going to hear more about, more states purging records because of clean slate legislation.
It sounds like it's not an overnight process when the state does go clean slate.
It is not an overnight process. California is a great example of this. They've passed clean slate legislation. It's up to every county to figure out how to fund the ability to go through and purge the records. It's not a state funding, whereas in Michigan, the judiciary took care of that. In California, it's county by county, and they don't quite know how or when they're even going to be able to start because of funding in California.
Okay. Tyra, I know you get this question a lot on a background screening report. Does the employer need to order a new report if the PII does not match on the report?
Yes. Quite simply, the answer is yes. If the name is wrong, the date of birth is wrong, the social security number is wrong, then yes, you need a new report. The driver's license all need to be correct. The potential for having a false clear due to incorrect PII, having the wrong date of birth, even if it's just you transpose two numbers in the day or the year, transpose two numbers in the social security number, all of that matters in making sure that you get correct data. We can't do a social security number check at the public record level at the court, but it is something that if your name is Michael Johnson, very common name, we are going to use that social security number to validate anything that we get back to make sure we're reporting for the correct Michael Johnson. And if that date of birth and that social security number has transposed numbers on it, we could absolutely have a situation with a false clear.
Okay. You mentioned California with regard to clean slate. Can you just talk overall what is going on in California with background screening this year and some of the pending legislation that our audience should be aware of?
Yeah, California has been very active in regards to pending legislation specifically for background screening. Also and some of the cities have been very active in specific legislation for tenant screening as well. Basically, there's a couple of bills out there right now. There's SB 809, where the California legislature is basically going to stop allowing background checks to happen in the state of California. A lot of this is because they've determined that 1 in 4 Californians have a criminal record that prevents them from getting a job. If you can't do a background check, you can't have something that prevents you from getting a job in a background check. It's a little scary. Actually, just as of this past Friday, there's been some new words out on the street that the incoming legislature is questioning the need for this. They're not sure it's necessary. The bill is in a hold right now, so it hasn't passed. It still could. It still could not. If you're in California or you do business in California, contact your legislators, because if this bill passes, there will be no more background checks in California. Another one in California that's also interesting has to do with companies like Vault. And we are a consumer reporting agency, and this bill is in the process of making Vault the equivalent of the employer when doing a background check in the state of California. If that bill passes, we're held to the same liabilities and the same standards as the employer, which in sense would almost nearly end background checks in California.
And again, because I'm sure you scared the audience who is doing business in California, hearing you might not be able to do background checks in California, what can they do if they want to weigh in on this?
Contact your legislature. If you're outside of California and you do business in there, get a hold of somebody in the California legislature and press your case. If you're in California, contact your representatives. These bills are important.
Great.
And they've been a little quiet. They're not ones that are necessarily out there screaming, but they have been introduced this year.
We've hit Michigan, we've hit California. What are some of the other troubled jurisdictions right now that are impacting your team's ability to complete a background report?
Right now, my biggest trouble jurisdiction is Kansas. Kansas, almost a little over 60 days ago, had a cyber attack. This cyber attack is probably one of the biggest reasons for delays in getting reports completed this year alone. Kansas has been down for 60 days. We're hoping they'll be up by the end of the year, but there's no guarantee. We had Michigan down, Louisiana, multiple jurisdictions not Michigan, Massachusetts was down right around the beginning of November for about 2 weeks. We had half the jurisdictions in Louisiana down earlier this year. The cyber attack is becoming a big thing that is outside of court control in regards to delaying results. And that's just impacting a lot of it. We do have the normal jurisdictions like Maine, New Hampshire, Wyoming, Sacramento, California, where just due to either procedural and judicial regulation and or staffing issues, are troubled jurisdictions that impact getting a report completed quickly.
Let's talk pre-adverse and adverse. I know this is a question that comes up. It's under the Fair Credit Reporting Act. When do employers need to send pre-adverse and adverse action letters?
Pre-adverse and adverse action letters are so important. You need to send them anytime you are making an adverse hiring decision based off of the background check report that your background check company has done for you. If you're using something on that report, then you need to send a pre-adverse and an adverse action letter.
Last question, and then we're going to open it up to Q&A. So again, to the audience, we're going to close out your section with the last one. What happens if a background screen report is ran and the applicant or employee tells the employer that information's wrong on it? What should happen?
Anytime an applicant states that a report is wrong, a dispute needs to be initiated. At Vault, we will accept that dispute coming from the employer, our clients, or we will also take it from the consumer. To us, it's one and the same, but a dispute needs to be initiated. That dispute automatically triggers a reinvestigation of whatever information the applicant says is incorrect, and it is required to be completed within 30 calendar days. The dispute management process is regulated under the Fair Credit Reporting Act. It's not something that can be ignored. At Vault, we strive to get it done a lot sooner than 30 days, but sometimes, depending on what the issue is, it may take up to that time. If something is removed from a report due to a dispute, especially one that hits that 30 days, and information has been received to determine that the information was correct to begin with, it is possible to have that case or that issue put back on the report when that extra additional information is received.
Great. All right, that brings us to our Q&A section. We've had a number of questions come in under Q&A. We're going to try to get through all of them. We may run out of time. And we will follow up with those who ask questions that we don't get to. Melanie, this one's starting with you. Can DOT physical exams be completed online? And is that conducted through an FMCSA website?
Not currently. There is an electronic there's a PDF version that FMCSA provides. And then there are some providers out there that do have it in electronic platform, but the clinic that the examiner works at has to subscribe to those services and choose to use those platforms, similar to some of our electronic drug screen options that we have. FMCSA does not provide that out of the box.
Okay. Mel, while we're with you on physicals, is sleep apnea a standard question on the DOT physical form?
It's nice and vague on the DOT physical form. There's two questions that ask, have you ever had a sleep study? Do you have sleep concerns, sleep issues? And the other one asks if you've ever been diagnosed with a sleep disorder. Nothing specifically says, tell me about your experience with sleep apnea. It's not as direct as I personally would like it.
Regina, I'm going to go over to you. This is a clearinghouse question, and it's a specific scenario here. But in this example, a man just applied for a truck driving position at a company in Minnesota. His CDL is currently suspended due to a DUI, which he says he's getting back on January 5th. The employer in this question has told him to reapply once they have his CDL. If he does reapply, how is the violation going to appear in the clearinghouse on the pre-employment query? And what does it mean for them as their potential employer? Suspended CDL due to a DUI. Would that be in the clearinghouse on query? And what does that mean to the potential employer?
If his CDL is suspended, it'll show up in the clearinghouse that he's prohibited because he has to have a valid CDL. And if it's suspended, it's not valid. Once it's reinstated, then it shows up that he's not prohibited as long as he has no other violations. If it's just a suspension, the states have to get that into the clearinghouse there. But the DUI in itself is not necessarily a violation. It depends on where he got the DUI or how he got it.
Right. I know this was covered already, but it's a common question. I'm going to throw this out to Dr. Steele and Dr. Ferguson. Can CBD oil cause a positive drug test?
Yeah. Do you want to go
Go
first?
for it, Suzanne.
Oh, unfortunately, the CBD products are over the counter. They're not FDA regulated. There's all kinds of things in there. They label it one way. That might not be what's on there. There's a lot of information, even that the government put out February 2020, the CBD DOT notice that advises drivers that they should not use any of these products without significant caution because it can cause them to have a positive drug test. So unfortunately, this is plant matter and there's a lot of different things in there. It's not a pure substance and it might not even be what's on the label.
Dr. Ferguson, anything to add?
I would say that for all practical purposes for us, be it workplace or monitoring, CBD equals THC. And I would encourage everybody, whether it's the workplace employer, monitoring program, to expect that, put it into your policies and your agreement with your participants, what your status of accepting that excuse is. Will you do a one-time retest and out, or not accept it at all, hard line, whatever you want to do, that's totally up to you, as long as you're not in the federal workplace, of course, because then it's documented what you're going to do. But address it before it happens, get it in there and do it. There is one lab, who shall go nameless, that is saying that a CBD THC ratio of 1 to 10 or less might be consistent with CBD use causing the THC. Anything greater than than 1 to 10 is not from CBD. Unfortunately, the only data for that is proprietary data, hasn't been given large scale studies, so I'm not advocating it, but there are attempts going on in the world to be able to differentiate the two, and we've got a ways to go to get there.
Dr. Ferguson, this question's coming in. I'm going to direct it to you. What is RMS? We referred to RMS a couple times. Briefly, what does it mean to be RMS?
It's not a racing stripe design on your sports car, let me put it that way. Although sometimes we call it recovery management services or solutions. To get into our testing programs, you pretty much have to study for it. Our programs are people who have some form of diagnosis or history of substance misuse, or a substance misuse disorder, or have had licensure issues for mental health reasons and are subject to a monitoring program. The people in our program have gone through some degrees of treatment, are possibly on probation or diversion. They are two very different programs, which I won't go into here, relative to relationship to the licensing boards, and attempting to get their lives back in order. And we want to, consistent with public safety and medical ethics, we want to help them do that to the degree that we can, and assure, to the extent that we can, compliance with the requirements of the state physician health programs, or whoever is the monitoring organization, to help them do that.
Right. Regina, I'm going to throw this question out to you. In a state where marijuana is legal, if the employer has a post-accident test with an employee who consumed marijuana, how should they handle that?
It depends on the state. That's unfortunately with marijuana laws in the state, every state is different. For instance, New York doesn't allow a lot of marijuana testing at all, whether it's post-accident. I believe they have to have reasonable suspicion to go with their post-accident, and in certain situations. Other states, it only does a marijuana law for pre-employment. There's no cut and dry answer for that because it does vary by state. Of course, the federal doesn't matter at all on the state level.
Right. Tyra, we've got a couple people asking. I think you really got their attention with background screening may go away in California. What was that state bill number if people do want to reach out to the representatives? What is that?
It's California SB 809.
Okay. California State Bill 809. All right. Here's one. Why does it take up to a week to notify the DER for drug screen issues, such as not being able to contact the donor or needing more information from the testing facility? We talked a little bit about this at the beginning, but let's just cover it again. Why does it take what seems to be a week for us to notify the employer when there's something going on with the drug test? Dr. Steele, Regina, I'm going to throw that out to the two of you.
Do you want to go first, Regina?
Yeah, I'll hop in there first. One of the reasons is sometimes we don't know about it that before a week. If it's something that the lab has to correct, the lab has to make so many days worth of attempts to correct it before they even report it to the MRO. The MRO might not know. The other reason that it might factor in there is the DOT regulations require certain things, such as making 3 attempts spread out over 24 hours. So until we get all the paperwork in and then the MRO makes those attempts, it might be a couple days. Yeah. The other thing is the MRO does try to correct some of the issues before reporting it out. There are some issues that have to be corrected that are listed as a correctable flaw that have to be done before reporting it out. And we can't give some of that information to the employer per DOT.
And then after we've made those 24 hours, and then during that period of time that we're waiting for the donor to call us back, if they call us back and they give us information that's hard to verify, then another holdup is that we're on the hold waiting for the pharmacies or someone to verify a hospital, the documentation that shows that they've received the medicine. We have to verify their legitimate medical explanation first.
We are coming up on time. We're going to get to one more question. Melanie, I'm going to throw you the last question that was submitted. I see there's an authorization form that's required now. Some labs require it, some don't. What is the rule about authorization forms? Are they required? Are they not required? Specifically, LabCorp and Quest.
Yeah, so if you're talking about at their patient service centers, their PSCs, they do need to know what tests to perform. They do need prior authorization to know what panels to run. Our systems will generate those electronically for the user. Clinics, though, outside of LabCorp and Quest don't require authorizations. We highly suggest that they request one so that they know who to bill, what services to perform, and things like that. But it's up to the clinic outside of those networks.
Panel, I want to thank you all for your time today. We covered a lot in an hour, and I want to thank you all for joining us. To our audience, I want to thank you for joining us today and spending an hour with us. If you're currently using Vault for employment screening or recovery monitoring services, we hope today's presentation leaves you with a sense of security. You made the right decision in trusting your needs to our expert team. If you're considering moving services to Vault, we also hope that today's webinar showed we have a group of experts who are ready to assist you with understanding the nuances when it comes to drug testing, OCHealth, and background screening. If you have any questions that come up following the call, you can go ahead and email us at compliance@vaulthealth.com, and we'll make sure that the message gets routed to the right department. On behalf of our panel, on behalf of Vault, I want to thank all of our attendees today, and have a great rest of your day. Goodbye.